got 500 members and he's not rolling. That's bullshit.
Good morning. May I have your attention, please? If you have not signed in, please take this opportunity to do so, and please silence all cell phones. Thank you very much.
All right, good morning. This meeting of the Louisiana Tax Commission is hereby called to order. This meeting is being held at the offices of the Louisiana Tax Commission at 1051 North 3rd Street, Suite 225, Baton Rouge, Louisiana. The date is Wednesday, April 17th, 2019, and the time is 10:01 a.m. Please call the roll.
Chairman Shaharney.
Here.
Commissioner Wagasback.
Here.
Commissioner West. Commissioner Verscher.
Here.
Commissioner Wood.
Here.
4 present and a quorum.
Thank you. There being no old business to take up at this time, I'll accept a motion for the approval of the minutes of the April 17th meeting.
Make a motion that we approve the April 17th minutes as presented.
I'd second that.
Commissioner Verscher.
Yes.
Commissioner Wagasback.
Yes.
Commissioner Wood.
Yes.
Commissioner West is absent. Chairman Shaharney.
I abstain. All right. We'll begin the appeal hearings today. I'll ask anyone who is planning on testifying to please come forward to be sworn in today as a witness.
I'm not as good at this as the other Mr. Hoffman, so if you're going to testify, raise your right hand. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God? And follow Russell's lead here.
Russell Ormerod, Orleans Parish Assessor's Office, I do.
Thomas Sandoz, Orleans Parish Assessor's Office, I do.
Carl Kehoe, Real Estate Tax Group, I do. George Wallace, Tax Commission, I do.
Thank you.
Thank you. All right, the first item on the docket today for the appeal is the appeal of Alvin Smith versus the Orleans Parish Board of Review, docket number 18-22171-002. This is an appeal by the taxpayer. I'd like to note that the property owner taxpayer is not present this morning for the hearing. Also, and I don't believe the property owner had submitted any evidence unless, am I correct on that, Ms. King? That property owner.
There's just a taxpayer appraisal that was submitted to the
Right,
Board
but
of
that was submitted
Review.
by the assessor's office, I
Yeah.
believe.
Yes, sir.
So, okay. All right, so we don't have that. And it was a dual appeal, is that correct? The assessor's office has dropped their appeal?
Yes, sir.
Okay. All right, well, let's go to the assessor's office then. Tell us what you're looking for us to do.
Good morning, Commissioners. We initially had appealed 3101 Erato Street, did some further research into the matter, and decided to drop our appeal. In order to expedite the appeal process, the assessor's office is okay or agrees with staff's recommendation.
So basically, the assessor's office is accepting of the Board of Review value, which is $445,000?
Yes, sir.
Okay. All right.
Which is in line with the Board of Review actually kind of adjusted to.
Yes, sir.
Like the agenda.
Yeah. Our staff appraisal, we'll hear the testimony on that, but our staff appraisal was $447,000, which is within $2,000. So
Sure.
we would default to the
Board review.
Board of Review
Okay.
in this particular case. All right, well, let's hear about our appraisal. Yeah.
Okay, I physically inspected the property on 3101 Erato Street. It's a mixed-use office warehouse. The land value was uncontested at $130,000. I did a market approach to value and came up with $447,000, which would be $317,000 for the improvements and $130,000 for the land.
Okay. All right, so basically your appraisal is in line with the Board of Review value, is that correct?
That's correct.
There's a $100 difference, it's not much, between the appraisal and the border review in lands uncontested. What number should we go with?
Theirs was 129,900.
Yeah, I would
Yeah.
say just take the border, I
Okay.
mean, the numbers
I got you.
are negligible, I mean,
Yeah, I mean, I
Yeah.
rounded mine to
All right.
130.
margin of error thing.
You need a motion?
Yeah, I mean, yeah, please.
My motion would be to uphold the parish border review. The valuation set at land, $129,900, improvements at $315,100, for a total of $445,000.
Second.
Commissioner Vercher?
Yes.
Commissioner Wagasback?
Yes.
Commissioner Wood?
Yes.
Commissioner West is absent. Chairman Shahardy?
Yes. All right, that takes
Thank
care
you,
of that one.
Commissioners.
Thank you. All right, the next item on the docket is the appeal of CDB Carondelet LLC versus the Orleans Parish Board of Review, docket number 18-22171-011. Now, this involves, let me see. All right, this is not the one involving the RTA?
No, sir.
Okay, that's the next one or the one after that, okay. All right, well, this is a taxpayer appeal, so, Mr. Kehoe, you free to go.
Thank you. Good morning, Commissioners. My name is Carl Kehoe, representing the appellant. I'll be brief in my comments. This is the property at 619 Carondelet Street. It's commonly referred to as the Scottish Rite Temple. It's about an 18,240 square foot building. Property was constructed, parts of it I think that were built in the 1800s, most recently in 1920. It served as a headquarters of a fraternal organization for many years. It's been vacant for about 7 or 8 years or so. The ground floor, the first floor, it's a two-story structure. The first floor is an open area, meeting area. The second floor is a theater, not in a movie theater sense, but a reception hall, I guess, auditorium-style theater. I have some photos attached in Taxpayer Exhibit 1, item number 7. The property has an annex building next to it that's not subject to an appeal, but I reference that only because there is a lease for both buildings. The annex building is connected to this building at 619 Carondelet Street through a horizontal penetration. And in the past years, the fraternal organization used the buildings together as one. But that one is not subject to an appeal, but I reference it and only because it's going to be incorporated, I think, into the subject lease. Both of these properties are subject to a lease. That lease is attached as Taxpayer Item 1, Exhibit number 6. I'm sorry, Exhibit 1, Item number 6. When I allocate the amount of that lease, this property for this building that's subject to the appeal is leased for $10.30 a square foot. If we take a modest 10% expense ratio and
Now,
a
excuse me one second. In this lease, what are the expense obligations of the landlord?
Of the landlord, there are really none. It's a triple net lease, so the expenses that I'm figuring would be those that the landlord has as...
Well, that's what so I mean, you're deducting for expenses, but if he has no expenses under the lease, why deduct for expenses?
Well, what I'm doing is figuring the landlord, sitting there as an owner who just receives rent monthly. I mean, there is going to be expenses that I'm figuring of legal. There's going to be some kind of insurance that he has on the building,
But
some
is
kind
the
of
taxpayer
liability.
required to carry insurance?
The taxpayer,
For the benefit of the landlord as well?
yes, the taxpayer is obligated under the lease to have liability insurance for the building.
What about fire insurance? Is the tenant
It's contained in the
required?
lease. I would imagine that, yes, there is
Yeah.
some liability casualty insurance that they
I mean,
require.
I'm just asking the question because it just seems to me there doesn't seem to be any expenses for the landlord involving the property, and that if he does have an expense, it's more of him wanting to double down
Well,
on expenses.
in terms of
On-
insurance, yes, but I would imagine legal, accounting, just administrative cost just to own the building.
So did you estimate these, or did you get actual information?
I did estimate them. I estimated them to be 10%, $18,411 annually.
And there was no way to know the actual?
No, I say there's no way to know. I didn't know that. We're working on behalf of the
Owner,
not the owner of the property, the lessee of the property, who's
Lessee.
obligated to pay the taxes.
okay.
So yes, in developing my pro forma statement, that is Taxpayer Exhibit 1, Item 5, you'll see on there the commercial lease revenue is actual from the lease. My expenses are estimated. And as Chairman Chahari pointed out, there are estimate of expenses as a landlord might have for legal, accounting, perhaps some umbrella insurance policy or something along those lines. We estimate it at 10%, it comes out to be $18,411. Capitalize that, the net operating income as a result is $165,703. Capitalizing that value, we come up with a value of $1,515,000 rounded. So that, if there are any other questions, that concludes my presentation for this.
Okay. Any other questions? You're at bat, Mr. Sandos.
Good morning, Commissioners.
Good
Thomas
morning.
Sandoz, Orleans Parish Assessor's Office. Carl's correct. The property is comprised of 2 parcels, only one of which is the subject of this appeal.
Pull the microphone a
Oh,
little
I'm sorry.
closer.
Yes,
Sure.
sir. I'm a little under the weather, so bear with me. So it is comprised of 2 parcels, but only one of the parcels is the subject of the appeal today. Just a general question for my own edification, and I'm not trying to be argumentative or anything like that. Does the lessee have appeal rights, generally speaking, or does the appeal actually have to be filed by the owner? And that's, I mean, it's either here nor there. I was just,
Yeah, maybe.
I was wondering what your
Is it,
opinion on that.
what is in the lease with regard to contesting? Sometimes, a lot of times, these leases will have in there a provision that the landlord will agree to cooperate with the lessee.
Okay,
I'm not saying that's the case here.
right, right.
You know, I mean,
I just didn't know if that was, just a general understanding or, and again, I'm not trying to be argumentative.
are you trying to derail this, or
No, no,
just-
no, no, no,
okay,
no, I'm not trying to do
okay.
that. It's really just for my own edification,
Sure.
just so I know
Yeah.
moving forward. Now, I know.
Normally, what you would do is look in the lease that you'd have terms in the lease that would say that the landlord agrees to cooperate with
Right,
the tenant in any contest of value of property taxes, and that would, agree to sign or do whatever.
Right.
I don't know that that's in this, I don't know that that's in this lease or not. I did not read it
I don't know
with
either.
with that in mind.
But it's, I mean, it's
I mean,
been
the lease addresses that it's the tenant's obligation to pay the taxes.
so therefore,
Well,
does
yeah.
that translate into,
not necessarily, but I'd be looking for, I mean, I didn't read the lease.
Uh-huh.
I reviewed the lease, but I wasn't reviewing it with that
I
in
just,
mind.
I didn't know if you, being a former assessor,
Yeah.
had any opinion on that, or, I mean, it's been our practice
Well-
in the past that,
I mean, as an assessor, I mean, if I was gonna get a stickler on it, I'd say,
Right,
come back with a letter from the property owner
right.
saying the tenant has the right to do
Right.
this, you know.
And I don't know,
Yeah.
Carl, if you have any thoughts on
Ma'am,
that.
Mr. Cook, I think Carl filed, I think
He-
you filed appropriate paperwork.
Oh, yeah, there's, you know, a
in the
copy of the
name
lease.
of
and
the
like I- you know, I
owner
just-
of the property. Let's see.
We have, our appointment of agent is signed
Yeah,
by
appointment.
619 Carondelet LLC as lessee of the CBD Carondelet.
Okay.
So it's actually not signed by the property owner. And the
Right.
lease does address the tenant's obligations of payment of taxes.
Yeah.
I'd have to comb through it in detail to see if it specifically says that the owner can, you know, contest taxes or assessments. I'm sorry, if the tenant can contest the taxes, the assessments. I think it would, this is the first time I'm hearing of any objection
Well-
by the assessors.
Oh, no,
office.
no,
I mean,
it's not an objection.
The
I was-
question
I
is
was
whether or
just
not the
trying-
assessor's office is,
I was just trying to clarify.
I'm saying derail, I don't mean that in a derogatory way,
No,
but that's
no,
the only,
no.
that's the word that came in my
I
mind.
think it's a good question.
I do too.
Yeah.
I think
Yeah,
it's
that's a
No, I
Good
think that in
question,
the,
and we need
just
to know
in the
the answer.
future, I would recommend that an appointment of an agent come from the property owner.
Sure.
Rather than
The lessee.
from the tenant.
Right.
Okay.
Of the property.
Again, it was just
Even
a-
if the lease says in it, although I think that may cover it, the lease says that the tenant has the right to stand in the shoes
Of the
of the
owner.
owner
Right.
in this kind
Says
of
it, yeah.
contest.
Yeah, and I'm not trying to
context.
derail it or anything
Okay.
like that. It was just, it occurred to me that I didn't know if, you know,
Yeah.
if you all had an
Page 5.
opinion on it. or-
But Carl, is the owner aware?
I don't know the answer to that question, whether they're aware of this proceedings today or not. I'm not sure of that. 619 Carondelet certainly is. I mean, this is
Yeah.
their tax obligation that, you know, they've paid the taxes, portion under protest and a portion uncontested.
Okay.
Okay, anyway.
All right, let's move on.
Sorry about that.
That's all right.
The property, I guess the property owner in 2017 reached a settlement with the assessor's office for the 2017 tax year at $2.3 million for this particular parcel. The other parcel was also settled for $621,000, but that parcel's not under appeal. The property did transact in December of 2014, both parcels, for $3.25 million.
How much you said?
$3.25
Okay.
million, and that's cited in Mr. Wallace's appraisal. So, you know, the assessor position is, you know, we reached a settlement in 17. The value and the assessment has not changed since then. So we would ask that the commission uphold the Board of Review's decision.
Let's see.
And you reached the settlement with the property owner?
I believe so. I believe so. I wasn't personally involved in it, but
And I
yes.
see that that lease was effective 2015, so there was no tenant change. It must have been the same tenant associated with that particular.
If I can interject and clarify and address that, the original lease that was entered into was between, and this is item 6, CBD Carondelet LLC and Nola Luna LLC. Nola Luna, my understanding of that tenant at the time was someone who was going to renovate this property and bring it back into commerce as some kind of dinner playhouse kind of thing. Those plans didn't come to fruition, and that lease was subsequently assigned to the current 619 Carondelet LLC. And you'll see that lease, the last several pages of our taxpayer exhibit is the first amendment to the lease where
I
it
got it.
cites in
Yeah.
the appearance clause. The lease was further assigned from onto Crosby Land Resources and then on to 619 Carondelet LLC. So I'll leave it at that, but I have some rebuttal things for the commentary unless you want me to.
Yeah, no, let's let Mr. Sandos.
I mean, that's basically, you know,
Okay.
all I have to say.
Okay.
Other than, if there's a change in the tenancy, does that necessarily affect the value of the property?
A change in
In the tenancy, if there's a new
Yeah.
tenant that comes in, does that necessarily affect the value of the property?
it would depend.
Right,
You know.
right. So-
I mean, obviously, if the first tenant couldn't meet his rent obligations, and the landlord's faced with a vacant building, he may lease it to someone else, and he may lease it for more, he may lease it for less,
Right.
you know, so.
And again, I do not know who entered into that settlement
Yeah.
agreement. I can only assume it was the owner. So that's basically our
This
position.
settlement agreement happened when?
For the 2017 tax year.
So either it was the property owner or it was the new tenant.
It certainly wasn't the new tenant that I'm representing today,
Okay, so if it were but if it were the property owner.
or it could have been
I'm
Nola
just-
Luna, the
I'm trying to
original
think
tenant.
through this. If it's the property owner, he relayed that to the new tenant, or the new tenant knew what the taxes were gonna be, I'm assuming, if he did his due diligence.
Yeah, yes, the new tenant, 619 Cronolette LLC, I would imagine knew the, I'm not sure whether they were aware, I can tell you 619 Cronolette was not aware of this settlement agreement a couple of years ago, because when I posited this, told them this, they said, well, that wasn't us. We didn't enter into a settlement agreement. So I don't know if you have a name for who that was. The owner's CDB Cronolette is Craig Bowes, who you'll see on the signatory on the lease. And that settlement agreement was not this current 619 Cronolette LLC tenant.
I can only assume that the settlement occurred between the assessor's office and the owner. Because typically during an open roll scenario, you know, we need to verify.
That's who generally receives the
We need to
tax.
verify ownership in order to discuss the assessment. So again, I don't know for sure, but I can only assume because that's typically how things work during that time.
Do you know what the basis of the settlement was, how y'all arrived at the 2.3 million?
No, sir, I do not.
Because when you got that, the current lease doesn't support that value if you're just doing an income approach.
Correct.
So I'm just trying to figure out if there was something
Correct.
else that was
But
involved.
that's why I said earlier, you know, if, just because there's a change in the tenant, does that necessarily reflect a value change?
Only if the terms of the lease change or the rents changed, and I don't see that happened. I think the rents stay the same.
Well, like Carl said, you know, the lease that was in effect was just assigned to the current
Correct.
tenant.
And the settlement value of $2,003,000, that was for just the property that's under appeal?
That's correct.
It did not include the other building?
No, but there was a
So-
separate settlement on the other
Separate
building.
And what was it?
621,000.
So those two together equal the 3.25 million that they paid for. It's pretty close. Possibly the owner put more value on the piece of property. I'm not sure what the status of the other piece of property is.
I did
Because
some.
someone else was paying the tax.
I did some calculations based on the settlement amounts for
Mhm.
both properties, and I come up with $2.925 million.
Okay.
Yeah.
If I'm,
Sure.
add some comment, the settlement, 2.95 million, is for, yes, both of these properties. The one under subject of appeal and the neighboring one at 621,000. That 2,950,000 is exactly 90% of the acquisition price of 3,250,000. I have the property record card for both of 619 Cronolette and 621 Cronolette as taxpayer exhibit 1, item 4. The reason why we didn't appeal, we did appeal originally the neighboring annex building at 621, but withdrew the appeal. We didn't have a question of the value because the value we thought was appropriate. On a per square foot basis, I'm trying to find my notes, on a per square foot basis, that building value of the neighboring property is $44 a square foot. $44 a square foot. The one under appeal today is at roughly $83 a square foot. We are requesting a value that is around $40 a square foot. The neighboring building is lower, and it's commensurate with the value that we're requesting.
But is it the same quality of building?
It is. Both of them, and Mr. Wallace, I guess, will testify. We walked through both of the buildings. Both of them are functionally inadequate right now. They're not ready for occupancy. They would need substantial renovation to upgrade building systems, interior finishes, ADA compliance. all of that would be required. The photos you see are just of the building that's under appeal. The neighboring property also is two-story, same thing. Ground floor is some kind of administrative office area. The upper floor is an auditorium style. The ceilings aren't as vaulted, but it is open auditorium style with a stage and some seating where they would perform rituals and functions for their fraternal organization.
Under the lease, who's obligated to make those improvements? You're saying the property needs substantial upgrades, so who's obligated to do that?
I think it would be up to the tenant to do that. I'm not aware of the ownership contributing any dollars to that.
Okay.
Would it be safe to assume that when the property transacted in 2014 for $3.2 million, it was in a similar condition as it is now, or?
Well, you would think it's 5 years better.
Well, I mean, and I think Carl
Yeah.
will testify that, and so will George. I mean, there's not much that's happened to the property since then.
Yeah, that's correct. I don't know of any improvements that have been made to it.
But I do have a note that there was plans, if you will, based on a NOLA.com article, that the plan was to convert it into, like Carl said, like a dinner theater, some sort of thing like that. But it apparently never came to fruition.
You said there was a settlement. What was the original valuation?
Well, in 2016, the property that's under appeal was valued at $2.5 million. But that's 2016 tax year. I don't know if you have any.
I don't. The 20, which year was adjusted? The 2017?
2017 was the settlement year, yes.
And what was do you have the proposed assessed value for
I do not.
2017?
I do not. Unless it's in here. No, I don't. And I believe that was a settlement of the Board of Review appeal, I think. Based on the dates that I have here, the settlement was reached in September of 2016, which is right around the time of the Board of Review hearing.
Okay. Yeah, I see y'all usually put a BOR notation in here.
yeah,
There's no-
So from the assessor standpoint, y'all reached a settlement. Is there any argument about, price per foot or another valuation approach to anything to dispute the income approach? I'm just trying to figure out, the struggle is we've got a staff appraisal that it's above what the taxpayer's requesting, but not quite, obviously far off from the settlement amount. That's why I was trying to figure out if we just had some better information on how we reached that settlement. It
Yeah,
sounds like it was a 90% of the transfer price.
That's what
everybody
it was,
agreed
of
to.
which the
And y'all
current
prorated
tenant
it to
had
two properties.
no part of that. I think they stepped into and acquired this lease and started having to pay the property taxes and wanted to address this.
And the building's not in commerce?
It's not.
They're not using it or,
No.
yeah.
It hasn't been for quite some time, obviously.
The lease is being paid, as far as you know?
Oh, yeah, as far as I know, they're making their lease payments, right. There's no default that I'm aware of. And they've certainly paid their taxes because I've delivered under protest the portion and paid the uncontested portion for them.
Now, you did the income approach you didn't use a discounted cash flow, you just took 1 year's lease. Is there a reason for that, since you have a lease with, what is it, about 20 years or so of rents that have been established?
I did not do that because I wasn't sure how to account for, and I don't know the cost of rehabilitation. Also, my understanding is that the assessor's office will typically not use a discounted cash flow analysis. Oftentimes, they'll look at historical leases either pulled up from CoStar and analyze them that way.
That's correct. We usually just do direct income capitalization.
It looks to me like it's about roughly a round number, about a 7% return, based on the $2.3 million, of what the net income is. $164,000, something like that, on the net income. Is that correct?
I'm not sure whether,
I mean, you had
got me through that?
You had an allocation of 2.3 million. Actually, I guess the allocation, probably something less than that, because the 2.3 million that was allocated to this building, was, you said 90% of what the sales price was, Mr. Sandos?
That's, well,
Roughly.
if you do the math for both properties.
Right, and
it
prorated.
It works out to about 90%.
About 90%.
For both properties.
Yeah, so it's probably something less than 7% return. No. All right. Let's hear from Mr. Wallace.
Okay, good morning again. George Wallace, Louisiana Tax Commission. I physically inspected the property at 619 Carondelet on March 20th of 2019. The land value was uncontested at $792,000. As Carl said, the building is in fair to average condition and needs some renovation. I wasn't aware of the lease. I never got any of that documentation, but so I couldn't analyze it. But I did do a projected income approach on it and came up with $11.50 a square foot, which is about $1 higher than I guess it's a long-term lease. And came up with the final value of $1,586,000, which would be $792,000 uncontested land, $794,000 for the improvements.
And you were used what for your rent, per square foot? Is it,
I used $11.50.
$11.50, okay. It's actually a little higher than the $10 if you.
Yeah,
quoted
it's
earlier.
about what's that, about $1?
Okay.
All right. Any other questions?
I'm prepared to make the motion.
Chairman Shahardy,
Please.
if
Yes.
you weren't here last week, and this issue that not an issue, but a question that I'm about to raise. If a property transacts within the parameters of the lien date, why is that sale not considered?
Well, first off, we don't sales chase.
No, I understand
You
that,
know,
but just in
uh,
the analysis of the market, why, is there any reason why that sale would not be considered?
You know, it could depend on a lot of factors. I mean, people really want something, so they might pay more. Somebody wants to dump it, get rid of it.
Right.
They might take less. You know, it just, I think that, I'm not making any assumptions about the purchaser of the property, what kind of purchaser it is or isn't, but, I would suggest that you can look at the sales price, but I think you would have to do a separate appraisal of the property to see. I mean, if if the property sold for $2 million and you do an independent analysis of it and you come up with a value of $1,950,000, and you wanted to use the $2 million sales price, I'd say go for it.
Right.
But if you did an independent analysis and came up with $1.5 million, then I think you'd have to look at it and say, it may not be worth $2 million. It might really be worth $1.5 million, and the guy just
Right.
overpaid for it.
Right. And I guess we don't know if the
Well,
purchaser had an appraisal done at the time of
Yeah.
acquisition.
Yeah.
And I guess I would also say that you also don't know when somebody underpays or when a relative sells something, you know what I mean? When you're
That is-
underpaying, and so
that is-
then you're cherry picking because you're gonna go, ooh, let's use the
Right.
big one, but then you
That's
see
true.
something
Yeah.
where
Yeah.
the grandmother sells the granddaughter something cheap.
Sure.
I don't know if it's heresy to say it like this, but, I think the sales price can be an indicator of value, but I think it has to be supported by
Other sales?
other sales, which is a market approach,
Right.
an income approach, or a cost approach.
Right.
As appropriate.
Right.
So, certainly an indicator. And you would like to think that people buy and sell property based on what it's really worth. But we know that that's not necessarily the case, it's like a piece of property, let's say that someone wants to develop, and there's one piece on the corner that guy just doesn't want to sell.
Right.
And they offer him what it's worth. They offer him 10% more, 20% more, 100%. He still don't want to. Finally, he sells for 3 times what it's worth.
Right. Right.
And the owner, the purchaser says, well, I bought all this other property at market. So if I take this little piece, even pay 2 to 3 times more than what it's worth, by the time I incorporate it into the much larger piece,
Right.
the damage isn't so bad.
Right.
And but that doesn't mean it's worth 3 times. It was worth 3 times to the purchaser,
Right.
but you and I wouldn't pay.
Right. And I guess we don't know what the motivation was
No.
behind this purchase.
Right.
I mean, I don't know if the
It
property owner.
appears from the information, the motivation may have been to purchase the property, and they had a reuse plan, and the first tenant's reuse plan got to be way, way out of budget,
Yeah.
Right.
and
That's possible,
all of a
yeah.
sudden they were upside down in it and looked for another user.
Right.
And that user now is probably trying to do the same thing, figure out how to make it work.
Yeah.
Now,
I agree.
Yeah. Anyway,
with that said, I'm prepared to make a motion. I would move on docket 18-22171-011 that we accept the LTC staff appraisal, set the value of land at $792,000, improvement value $794,000, for a total value of $1,586,000.
I'd second that.
Commissioner Varcher?
Yes.
Commissioner Wagasback?
Yes.
Commissioner Wood?
Yes.
Commissioner West is absent. Chairman Shahardy?
yes. And let me do some record keeping real quick, since I failed to do it earlier. It is the Tax Commission's policy to accept all documents into the record that were timely pre-filed in accordance with the Commission's rules and regulations. This will be done at the conclusion of all hearings on today's docket. Accordingly, there is no need to formally offer or introduce exhibits into the records during the appeal hearing. However, if you intend to object to the submission of any of the opposing parties' exhibits, you must notify the Commission at the start of your appeal hearing. As a reminder, this is an administrative hearing, and as such, the rules of evidence are relaxed. The Commission is inclined to review and consider all evidence submitted and to accept such evidence into the record. You all should have reminded me to do that.
Chairman, would you mind if I stepped out 1 second to get some
Sure,
water?
we'll take a quick, we'll wait for you. Good. The next matter on the docket is the appeal of the Jung LLC versus the Orleans Parish Board of Review, docket number 18-22171-012. And if you'll give me a half a second here. Okay, now this is the one that involves the RTA, is that correct?
Yes, sir.
Obviously, the assessor's office position is that the RTA does not cover the land?
That is correct. That's our
And where does
position.
that authority come from?
That's
That's your-
Assessor Williams' position, and I think the reason
Because
for
that's
that-
not what the statute says, and it's not what the Constitution says. The Constitution says that the State Board of Commerce and Industry, et cetera, may grant to a property owner the right to pay ad valorem taxes based upon the assessed value of the property for the year prior to the commencement of the expansion, restoration, improvement, or development. Property includes land and building, I believe. So,
I mean, in my opinion, that language is vague and should be, you
okay.
know,
Well, I mean, from legal standpoint, I don't think it's vague. I mean, I
Okay.
think it's pretty clear. I mean,
I think if
property
you
is.
inserted the word real property, then, you know, I think it would become more clear to, you know,
Well, look,
lay people,
you and I
you know.
both know legislative writings are not always the best.
That's correct.
But, you know, it does say grants to the
says
property, the right to pay taxes, the right to pay ad valorem taxes based upon the assessed value of the property.
The property, right.
And that,
I guess Errol's position is what it is, because when you enter into an RTA, you're not restoring the land. You're
I
restoring
understand
the
that.
building. So I think that's
Yeah.
where that position comes from.
right. And then, you know, then we get to the question of whether this is a legal issue or a evaluation issue. Again, the Constitution says that the commission, Board of Review, the commission, ultimately the courts, have the right to review the correctness of an assessment. So in one sense, this is, an argument can be made about the correctness of the assessment. On the other hand, it's a legality question of enforcing a constitutional provision in Article 23, Section 7, Article 23. So,
Yeah, I think the only thing we can rule on is the correctness of the assessment, but I also agree, I think it's, any exemption contract is gonna have the legal description in a map of that property inserted into the contract, so it clearly is covering, you know, the legal description or the property associated with legal description. So I don't know how do we exclude land from that definition.
And I would have to agree that if they meant to exclude land, they would have said improvements, or they would have made a real
Yeah.
specific reason to
mean,
exclude.
That's a
land.
shaky assumption.
well, property, you know, when you say
Yeah.
property covers the mud, covers a structure. I mean, it covers this chair. This
Yeah.
chair's property. You know, it's movable.
But it's my
Excuse-
understanding that
movable property.
the spirit of the RTA program is to allow the restoration, you know, of the building.
I understand.
And giving, you
So-
know, the taxpayer
so the
a break
assessors-
as that process.
So
goes on.
the other properties in Orleans Parish with the restoration tax abatement, the assessor's office policy is to
Exclude the land.
exclude the land and
Yes, sir.
freeze the improvements.
That's correct.
And nobody's complained?
Not until today.
That's interesting. That's very interesting. You got some clients out there, maybe.
Well, I know of another, I think this matter came before you of another taxpayer on their home. I don't know that
Yeah.
they had raised the issue. I don't know whether the difference between what the RTA land value was versus the assessor's
Yeah,
land
if I
value
remember,
was-
if I remember that one correctly, the homeowner was more arguing value. He was strictly looking at the value of the land, which we thought was overvalued by the assessor. He wasn't really making an argument involving the
I think he
restoration
might
tax
have-
abatement.
He might have gotten where he needed to go in another avenue, but I
Yeah.
remember in watching the proceedings
Right.
on YouTube, I remember seeing
Right.
that was certainly a concern of
Right.
his.
So, for our record, I mean, I jumped out of order a little bit here. It is a taxpayer appeal, so, Mr. Kehoe, why don't you go ahead and,
Thank you. And this panel and Commission Chairman, Chairman Shahardi touched on exactly what I was going to get to. But my first, I guess what I'll give you is a kind of the overview, argument of twofold. One, that the land is covered under the restoration tax abatement, and in the tax commission's either disagreement with that, or if you feel it's not the tax commission's purview to make that adjustment, then our second argument is that the land value should be rolled back or reverted back to its 2018 value, because we think it was adjusted this year solely because the restoration tax abatement was put in place, and that its value doesn't take into account the size of it. It's nearly 1.9 acres, and it's valued as if the front footage on Canal Street is the same value as that square foot that is on Cleveland Street at the rear portion of the square. So for the record, what I'll do is go through just some of my exhibits and talk about the issue of the RTA and describe to you some of the exhibits I have, which I think are, support exactly what the commission has said. This property, for the benefit of the tax commission, is the Jung Hotel, the Jung Hotel and Residences. It is, takes up the entire square of 369 at 1500 Canal Street. It was vacant for many years since Hurricane Katrina. The owner embarked on a renovation project, applied for and was granted and signed by the governor a restoration tax abatement contract, commonly referred to as an RTA. And as we briefly discussed, the RTA, we believe, and it's the position of the owner, that it covers both the land and the building. The land was assessed last year for a value of $45 a square foot, which is $3,691,000 rounded. The assessor this year increased that value, kept the building under the at its pre-renovated value, but raised the land value to $80 a square foot. So the land value went from $3,691,000 to $6,563,000. Now, the restoration tax abatement legislation, and we have provided for you in Taxpayer Exhibit 1, item number 4, excerpts from the revised statute. It's also contained in the Constitution and the Louisiana Administrative Code. And it commonly, and throughout the legislation, Constitution, and the Administrative Code, it refers to property in its collective term. What the assessor's office may be referring to when they talk about enhancements to the building, the program is designed for renovations to existing structures. And I think that is, if I can delve into the legislative intent way back in 1984 or 85 when this law was passed, my understanding is that they didn't want to have a restoration tax abatement for new construction on vacant land. So it is specifically for existing buildings, because the preamble to the statute is it is recognized for the enhancement of underutilized resources. So they wanted to bring buildings back into commerce. So it is available for existing structures within certain districts. But throughout the statute and the Constitution and the Administrative Code, it refers collectively to the property. In Taxpayer Exhibit 1, Item 4, I have, again, the statute and the Administrative Code, which, if you look at, the Administrative Code talks about the application process. In Chapter 9, Section 907B1 and B2, describes, among other things, part of the application items that are required. And attached to the application, item number 1 is proof of ownership or an act of sale. Item number 2 is a legal property description. We've included as Taxpayer Exhibit 1, Item 5, a copy of the property's act of sale. And on page 1 of that, the legal description in that act of sale is, and I have it kind of boxed and highlighted, and I'll paraphrase, the following described property, together with all buildings and improvements thereon. And then it goes on to describe that certain square of ground in the First Municipal District, square number 369, bounded by Canal Street, Cleveland Avenue, South Villery, and LaSalle Street. So the property, as it's described in the statute, as it's required in the application process laid out in the Louisiana Administrative Code, refers to the property collectively. The legal description in the act of sale includes both land and building. The enhancements that are made to a structure enhance the value of the land to the extent that that building is non-removable from the land. I think they're part and parcel. When one gets a homestead exemption, that homestead exemption is constitutionally provided to a taxpayer, and it's applied to the whole property. You don't diminish the value of the homestead exemption if someone's home is only valued at $60,000 and the remaining portion of the value is in the land. So our belief is that this statute and the contents of as it's written in the RTA contract covers both the land and the building, and to allow the assessor to change the assessed value undercuts the benefit of the RTA. Certainly when one makes enhancements to a building, the land value is increased as well. We recognize that, but the benefit of the RTA is to allow that property to be affixed at a certain pre-renovated value for a period of time. That's what the benefit and the incentive is. So that is my discussion and exhibits as it relates to the question of the restoration tax abatement. I have some discussions and some items to present to you regarding the valuation in the event that the commission thinks that, again, either the land is not covered or you don't believe it's in your purview to make that determination. I don't know if there are questions now regarding that, or you want me to go right into some of the valuation parts that I have.
No.
I want to make it clear that the value that you're actually requesting is the value that was determined at the time that the restoration tax abatement agreement was signed.
Correct. I think I understand your question. The
4.5
restoration...
million.
I'm sorry?
The overall value and then the breakout of that value.
Yes, the overall value is $4.5 million. The land value is $3,691,700. Improvement value, $808,300. That total value is $4.5 million, and that represents the pre-renovated value.
I just wanted to hear you say that.
Okay. And we have a...
We're talking land, but I wanted to hear the whole thing in the breakout.
That's a good point. That cleared it up for me, too.
Yes, the assessor's office, just to reiterate, the assessor's office this year, when they got the restoration tax abatement contract and addendum items and everything signed by the governor, I believe it was around the time of, say it was May, June of 2018, when they presented the 2018 assessment, 2019 assessment for public exposure in July of 18. That value, that assessment represented the lower and a fixed RTA building value, yet the land value was increased substantially to $80 a square foot.
Because that's what you have to submit with the application and attach to the contract, too, is that assessed valuation.
Yeah, that's part of the application
Yeah,
process
yeah.
that was presented.
Yeah.
That's in the Louisiana
Right.
Administrative Code refers to that, a plat map, act of sale, copies of tax bills, building permits.
And copies of the tax bills prior to any
Prior to renovation.
renovation being done.
Mhm.
Yeah.
Right. And this, and Commissioner Verscher may remember, when we talked about the land value of this was under appeal, I think, in 2015 or so, which is where that value comes from, the 4.5 million established, was that appeal. And the land rate, which was decided at that time, was kind of a blended rate, recognizing that the value of that square foot on Canal Street is not the same as the square foot of land that resides at the corner of, say, Cleveland and LaSalle. But that's the valuation items that I was going to discuss a little bit further. It's kind of a blended rate.
Because it's almost a 2-acre site, I believe.
It's the entire square. The building takes up the entire square.
Yes,
But
1.8
simply put, you are requesting that the land value be returned to the assessed value, the assessed value and market value that was on the property prior to the renovation work being done on the Jung Hotel
Correct.
property.
Correct. And it's been the same, I think, 2015, 16,
And that's
17,
based
18.
upon your interpretation of the restoration tax abatement that was granted to the property owner.
That's correct.
Okay, so you're asking $3,691,700 for the land, and the building was frozen at $808,300.
That's correct.
Okay. I mean, going through all of this, that's the bottom line.
That's the bottom line.
Right.
That's the
Okay.
bottom line. And the reason for that is the RTA.
Okay. All right.
Chairman Shahardi,
Yeah.
Carl was a little inaccurate in his description of the revaluation of the property. When the property was renovated, and we picked up the renovation, and the hotel opened, we revalued the entire property at $96,000 a key. And we allocated $80 a square foot to the land, because that's our land rate on that side of Canal Street. The building encompasses the entire square. So I don't, I mean, I understand Carl's argument that, you know, a blended rate, you know, so on and so forth, but if the building encompasses the entire square, how do you split it up? Just because the rear lot doesn't front on Canal Street, it's I mean, the building encompasses the entire lot. So the land value is the land value.
Well,
Even, you know, no, in my opinion, no matter, you know, what it fronts on, it's, you know, you can't like knock half of the building down and have a vacant lot with another land rate. In addition to that, the staff appraiser, Mr. Wallace, supports our land value.
I don't doubt for a second.
So I think what it really boils down to is,
I think this whole thing boils down to what the RTA
does the
says.
RTA apply to the
I mean,
land?
That's right.
I don't
I agree.
dispute the land value that you have out there.
Right.
As far as a value is concerned. In fact, when I realized it was $80 a foot, my first reaction was that sounded more than fair to taxpayer. I would have thought those values might be.
I thought you were going to say low.
I didn't say that, but I thought it was more than fair to the taxpayer. It was what my initial reaction was. And I don't have a clue what the values on Canal Street was, but it just sounded
More than fair.
maybe a little low, more than fair, okay? And it did encompass the whole square, so if you make an argument about the back part versus the part on Canal Street, it
Right.
does take some of that into account, maybe. The question really, that's not really the issue. The issue first is the RTA
That's correct.
and how that's resolved. If it's resolved in favor of the property owner, then the $80 a foot really is not relevant at that point, so.
Right, that was my point.
Right.
You know, the crux of the matter is, does the RTA
Right,
apply to the land?
right. All right, I know Mr. Wallace did an appraisal of the land, which,
Pardon me, Mr. Shahar.
Yeah.
Would you like me to, you want to wait on me presenting some things regarding the value question, or?
you may want to do that, or you may want to just keep your mouth shut.
Okay.
Unless you feel like you need to actually put something into the record. Uh, you know,
Okay, no,
you
that's
don't want-
fine.
You don't want to beat that dead horse, and that dead
Fine.
horse is already beaten.
Okay,
You're about to
Thank
cross
you.
the finish line, I think.
okay.
Mr. Wallace?
Okay, I'll be brief. I
Thank you.
appraised the property. I had 6 comparable land sales that ranged unadjusted from $47 a square foot to $125 a square foot. After adjustments, I was between $73 and $106 a square foot. Subsequent to my appraisal, I did pick up on 2 other comparables that were on Canal. One, if adjusted, would be $90 a foot. The second, if adjusted, would be $84. So they also support my final value at $6,563,000.
All right, I'm prepared to make a motion unless we have any other questions from the commission or
No, sir.
anybody else. All right, it's my opinion that the restoration tax abatement program applies not only to the structures, but it also applies to the land. And as such, the value of the land should be frozen, just as the improvements should be frozen under the RTA agreement. So with that in mind, plus the authority of the commission to review the correctness of an assessment, and while I think there are some legal arguments involved here, I think it crosses over into the correctness question. My motion is to fix the land value at the level that it was prior to the restoration, $3,691,700, improvements $808,300, for a total value of $4,500,000.
I'll second that.
Commissioner Vercher?
Yes.
Commissioner Wagasback?
Yes.
Commissioner Wood?
Yes.
Commissioner West is absent. Chairman Shahardy?
Yes. Thank you.
Thank you.
All right, the next appeal on the docket was the appeal of Walili LLC versus the Orleans Parish Board of Review, docket number 18-22173-005. Let the record reflect that the, what does it? I'm sorry. You're here still. All right.
He's
This
batting
is-
1,000, so why would he leave? I mean,
What's that?
I said he's batting 1,000, so why?
All right, it's item F on the appeal docket, Walili LLC versus Orange Parish Board of Review. That's a taxpayer appeal, so I'll ask Mr. Kehoe to go ahead.
Thank you, Commission members. Again, name is Carl Kehoe, representing the taxpayer in this matter. This is the Walgreens location at 6201 Elysian Fields. It's a 13,500 square foot building that's built in 1995, so it's about 23 years old. The assessor's office, their records incorrectly reflect the square footage as 14,344. Correct square footage is 13,500. I think the Tax Commission's appraisal has 13,800, so it's the assessor's office, their records are off a little bit. But we have, it's best described as a Class C drugstore in good condition. It's old, it's one of the older concept stores, about 23 years old. The value of the building, we have looked at Marshall Swift Valuation Services and come up with a value of the building of $1,200,735. That's after adding in some lump sums for light standards, site improvements. When you add the land back into that, we come up with a total value of $2,006,835. The overall value we're requesting is $2,672,000 rounded. That is what we derived using kind of a pro forma of what we estimate to be the rents of $25 per square foot, and an expense ratio, again, legal, management, a reserve for replacement by the ownership of 12%, an expense ratio, come up with a net operating income of $295,000. Capitalizing that results in our indicated value of $2,672,000. That's contained in Taxpayer Exhibit 1, item number 5. And attached to that are some lease comparables from CoStar, and item number 6 is some capitalization rate information that we've derived from realtyrates.com, looking at freestanding retail stores. And that's my presentation. I'm happy to answer any questions if the Commission has any.
When you did your, just out of curiosity, when you did your cost approach, did you include site improvements?
I added $200,000 for lump sums and site improvements. And I don't have the manual with me. Typically, when we do that, it's a percentage of the kind of the percentage of the line number 27.
That's the $1,300,918?
I'm looking at line, yes,
Yeah, okay.
yes, line 27. For paving, light standards, and
Yeah.
other things along those lines.
Concrete, what have you. All right.
Do you typically expense the reserves for replacement as part of your NOI or income approach?
Yes, yes, that's what. And the cost approach, although we looked at the cost approach, our value that we're requesting is derived using the estimated $25 a square foot rent.
All right. All right, well, let's hear from the assessor's office unless somebody has a question.
Thank you, Chairman Shahardi. This property was the subject of a Louisiana Tax Commission commercial ratio study done in 2015. And that's where the original building value of $1.68 million came from. And the method that the Tax Commission used to come up with that building value at the time was the cost approach. So that's where the total current value of $3.4 million originally came from. In 2016, the land was revalued at its current value of $806,100. The building value did increase to keep the total value as established by the commercial ratio study the same. So therefore, obviously, the assessment increased. But that's where those numbers came from.
And the 2.6 million, where did that improvement value come from?
That was the adjustment, because the land value went down to $806,100. So we just increased the building value to keep the total value the same, which was established by the commercial ratio study.
Back in 2015?
That's correct, yes, sir. And it hasn't changed
Okay,
since then.
But we had a revaluation in 16.
Of the land, yes, and the building.
Right.
But we kept the total the same because that number was
So you kept the 3,000,004
as established by the...
by the ratio
by the
study that
ratio
was
study.
done, but that was based on the prior reassessment cycle.
That's correct. I just wanted to let you all know that's where it
Yeah.
came from. That assessment has not changed since 2016. It was not appealed by the taxpayer up until this year. They appealed to the BOR. BOR upheld our number, and so here we sit. So the assessor's office would ask that the commission uphold the BOR's decision. And the current land value is in fact supported by Mr. Wallace's appraisal.
Did you, do you know anything about the building area square footage, that the discrepancy that was described, that y'all have it listed as?
No, ma'am, I wasn't aware of that. And Carl, what's the difference in our current square footage and?
Difference between 13.
Is it 844?
Okay.
I wonder what square footage was used as a part of that ratio study.
I would assume that it was our square footage,
Yeah.
which is, there's a difference of about 800 square feet.
Of course, once we get to a new cycle, anything that was done in the previous cycle really doesn't apply, just on its face anyway. All right. Mr. Wallace, you want to?
Okay, yeah, I physically inspected and measured the subject property. I came up with 13,800 square feet, which is indicated on page 3 of my report. As they mentioned, the uncontested land value is $806,100. Also did a cost approach to value and came in with $3,040,000 total, which would be $806,100 for the land, $2,234,220 for the improvements. Also did an income approach and came in at $2,742,000, and I correlated the cost approach and the income approach to a final value of $2,860,000.
The owner of this property, it's not Walgreens?
It's not. It is Wiley LLC.
Right.
Tax bills, assessment notices, everything are directed to Walgreens corporate office in Deerfield, Illinois. They're
Where at?
in Deerfield, Illinois. They're
Okay.
the taxpayer
Again,
of record.
and it's leased to Walgreens.
Correct.
Um, What are the obligations of the landlord with regard to the property? Does he have any does the landlord have any obligations
I
other than to
think
collect the rent? Is it a net lease, triple net
it-
lease?
it's triple net lease, other than collecting the rent. Typically how these Walgreens work, they pay everything, and so my pro forma and my assumed expenses are of a triple net lease where the owner/landlord is paying for his, any legal cost, annual accounting, some kind of reserve, 2% reserve for replacement, and that would be it.
You know, Mr. Wallace, you allowed for 30% for expenses, which again, in a triple net lease seems to be excessive or high. Is there a reason, or is that just typical of what you would allow for
It's,
in a rental situation?
normally we find between 30 and 40%, and I went at the 30. A lot of times the data that we get, they're not very forthcoming with expenses and things like that through the LACDB and different databases.
How about the cap rate used? I mean, this is a very credit-worthy tenant. I'm thinking I see them advertised all the time as low, using a cap rate of 6%.
Yeah, we use the RERC rates, and I use the average at 8.1, and I added it to the effective, and that was the rate that it came out with. I think maybe for that location, I think that rate may be a little bit more appropriate than something that's closer in.
So you so you took that into consideration based on location?
Right.
Okay.
His operating expenses, it gets you 3,582 contact capital.
You can bring them up back.
Yeah. See what it goes, you can do. Just through, just at 358. Going on to, you could be over. 340, could be over. Go with accessory.
Yeah, but so it's just doing the same thing.
Have to figure this out. Yeah, right, that's correct. Right. Yeah, that's true, you're right. Do we have any other questions or any other comments?
I'm prepared to make a motion.
Okay, that's fine, go ahead.
I'd move on docket 18-22173-005 that we uphold the board of review number.
I'm
Set-
sorry.
Set the
go-
value, land at 806,100, improvement value at $2,610,600 for a total value of $3,416,700.
I'd second that.
And let me make a comment before we vote. Looking at Mr. Wallace's appraisal, I do think the 30% for expenses is a little high. So I think if you use 10% for expenses and then capitalize it at our capitalization rate, it supports the value of the board of review. And that was my logic.
And y'all might want to check that discrepancy on the square footage for
Well-
those buildings to see what,
Yeah. Well, I think Mr. Wallace actually measured it, is that
Yeah.
correct?
Right.
He actually went out and measured it,
Right.
so.
Yes, ma'am.
And then-
I believe that square footage has been updated for the upcoming tax year.
And that 10% is very comparable to the expenses used by the taxpayer in his income approach pro forma.
Okay.
So-
Commissioner vote, Commissioner Varsher?
Yes.
Commissioner Wagasback?
Yes.
Commissioner Wood?
Yes.
Commissioner West is absent. Chairman Shahardy?
Yes. All right. Thank you all.
Thank you.
Thank you.
The Tax Commission hereby accepts all pre-filed documents and oral testimony into the record as Taxpayer Exhibit 1 in Globo, Assessor Exhibit 1 in Globo, and Louisiana Tax Commission Staff Appraiser Exhibit 1 in Globo for each appeal hearing conducted today, respectfully. The other matters listed on the docket today have either been withdrawn or settled.
Thank you all.
There being no other matters to come before the commission today? No. We're doing a transition from our servers here over to the state.
Okay.
And we had some downtime. And as a result of that downtime, the assessors were not able to transmit their change orders, and the tax sale data was not able to reach us in time for us to include it on the docket. It's my understanding that we may have that problem solved or virtually solved. So it's just one of those things when you make that transition that you do end up with the downtime. So that said, there being no other matters to come before the commission at this time, I will accept a motion to adjourn.
So moved.
Second.
Commissioner Varsher?
Yes.
Commissioner Wagasback?
Yes.
Commissioner Wood?
Yes.
Commissioner West is absent. Chairman Shahardy?
Yes.